Okay, thank you, Mr. Bishop. You've got the 10 minutes.
Yes, but that's just before the agenda. I finally got to what happened in the thing.
Yes.
And I said there were 5 important facts. So the first one is that the draft reports did not include a statement about the fiscal framework. That's common cause. The second is that the committee did not vote on the fiscal framework separately. They only voted on the report. That's also common cause. The third important fact is that
Okay, so just on that one, the committee did not vote on the fiscal framework separately. Did the report not contain the fiscal framework?
It contained a description of the fiscal framework,
yes,
but it didn't contain the statement you find in the final report that the committee accepts the fiscal framework.
So it is the statement that you say was not voted on?
So both. So one, the statement was not in the draft report. And the report, so when they voted on the report, they voted on something that did not include a statement accepting the fiscal framework. It included a description of the fiscal framework.
Now, what did they vote on then?
It's a very good question, Lord. So what happened is various amendments,
yes,
motions are proposed over the 7 hours of the meeting. And those are then voted on. And they voted up, or they voted down, but they're all amendments to the report. So various amendments are made to the report. None of these are reduced to writing into a new report that is then placed before the committee so everyone can read it and see what it says.
So when were these amendments made? Were they at the meeting or were they after the meeting via email and correspondence?
They were done verbally during the meeting.
Yes.
So that somebody will propose. So let's take Mr. Beasley of Action SA, because this is the most important one.
Yes.
So if I can take the court to page 05-19. So this is from Parliament's answering affidavit. And it's recording the amendment that Action SA proposed, paragraph 40.
So just give us a moment. 05?
-19, paragraph 40 of Parliament's answering affidavit.
Okay.
Yes, I'm.
Do you have it, Malaysia? So it says Action SA proposed the following amendments. The fiscal framework tabled by the Minister of Finance is supported, and I emphasize, subject to the strict condition that National Treasury facilitates. And what goes on is what I read to you previously that found its way into the final report. But the important difference is it's not just a recommendation, it's supported subject to the strict condition that. And that amendment is then proposed by a member of the ANC, accepted by the ANC, seconded by another member of the ANC, and adopted by a majority of the committee as an amendment to the report. And there were various other amendments to the report that were adopted. Amendments proposed by my client, by Mr. Mukatobi's client, were not accepted. They were voted down. But this is all happening verbally. Someone reads out an amendment, the vote is taken, it's either accepted or not, and the committee moves on.
So the secretary of the committee produced a draft, and this draft is debated in the committee, and amendments are made in the committee, and some are adopted by the majority and some are not.
Yes. And then a vote is taken, do we accept the report? And then people say, but what are we voting on? So we record this in our replying affidavit. It's page, you don't have to go there, I just want to give you the reference, 06/12 from paragraph 27, where we quote various members of the DA, MKP, the EFF, who are all expressing confusion about what are we voting on. Parliament's position is that what was voted on is the report with all the amendments that had been verbally accepted during the meeting, and implicit in that was an acceptance of the fiscal framework.
Did someone clarify, as questions were asked, what are we voting on? Did someone say, this is what we're voting for? The chairperson saying, this is what we're voting for?
So if one listens to the meeting, it's particularly sort of the last hour of the meeting where most of this happens. Sometimes yes, sometimes no. But ultimately, even after these clarifications, members are raising a concern that I still don't understand what we're voting on. Are we accepting the fiscal framework or not? Because what Action SA says is it says, we are against the VAT increase. Mr. Beasley says that expressly. He says, I want to be clear, Action SA is against the VAT increase. And then he says the amendment that is adopted is, we support is, so I want to get the wording correct, says, the fiscal framework table is supported subject to the strict condition that. And so there's two important points here, ladies. The one is that there's just never an actual vote on the fiscal framework as it stands. That's never put to the vote, and it's never in the report. The only report that is adopted is support with a strict condition.
But doesn't the fiscal framework form part of that?
But remember, Section 8.4 requires a clear statement accepting or amending. And what's here is acceptance subject to a strict condition. That's what the committee votes on.
But that's not an amendment in the true sense of the word.
Exactly, and it's not an acceptance in the true sense of the word. So it's neither an acceptance nor an amendment. So what is non-compliance with Section 8.4? That's the problem. The other problem, Lord, is this is very different from what's in the final report, which I took you to just before the break. There, the strict condition is morphed into a recommendation. But there's a world of difference between a strict condition and a recommendation. Because strict condition means if National Treasury does not come back with alternative revenue proposals, our support lapses. I'm not sure it's a resolutive or a suspensive condition, but either way, the support will lapse because the strict condition has not been fulfilled.
Can I just understand, at the meeting itself, the proposal by Action SA was adopted, that strict condition.
Yes.
But the report, in fact, did not refer to the strict condition but the recommendation.
Correct.
Okay.
Correct. And so,
and then also inserted was the acceptance.
Yes, which was not in the draft report prepared before the meeting and was never put to the committee during the meeting.
To which the DA, Mr. Brits, then responds and says that this doesn't reflect what was discussed, and then a further amended version is sent, and then he responds again later that evening.
Yes.
It's also not what was discussed.
Yes. And so, my argument is, my first argument was, even if you accept that just a recommendation, and that is in fact what the committee adopted, that's not consistent with Section 8.4. But it's not what the committee said. The committee said strict condition. It's watered down in the report. But a strict condition can never be, as your Lordship pointed out, either acceptance or amendment. It's conditional acceptance. And it is premised on the idea that the fiscal framework may change because Treasury may come back with an alternative revenue proposal which will be voted on in the House within 30 days, which will remove the VAT increase.
But can that still happen? We're not past the 30 days yet.
Notionally it can still happen, but the point for us is that when Parliament voted on the fiscal framework, the Houses on the 2nd or the 3rd of April, that's what we're challenging as unlawful. And we're saying that was unlawful because they needed a compliant committee report before them that accepted or amended the fiscal framework, and they did not have that before them.
So what did Parliament vote on?
When the plenary, when they voted in plenary, they voted on these reports that had this, was itself contradictory because it says we accept with recommendation, and did not reflect what happened in the meeting. Because what happened in the meeting was neither a recommendation, it was a strict condition, and it was not an acceptance because that was never.
So they voted on reports that were prepared by the Secretary to the committee.
Yes. So
the Secretary took a view that there had been acceptance.
I think Parliament's argument is that they say it's implicit. Because we adopted the report subject to all the amendments we did, implicitly we accepted the fiscal framework. Our point is you couldn't have accepted the fiscal framework and accept Action SA's amendment. Those are mutually inconsistent votes. And so having a clear vote accepting Action SA's amendment means you could not have voted to accept the fiscal framework. Because you can't do both.
So then who came up with this acceptance?
I assume the Secretary drafted it, but it would have been approved by the committee. I don't know if there's an answer in the papers to that. I can look it up and give it to you in reply, but I'm not sure exactly who. But ultimately, it would be the chairperson who would have to table the report before the House. He would receive comments from the parties who would object to it, and various parties did object to it. He said, we don't think that was ever voted on. There's all the letters that are attached to the Carney Academic, from my client from EFF, who say we don't agree that that reflects what happened in the meeting. But ultimately, the chairperson puts it in. So maybe that's why the adoption of the fiscal framework is unlawful. whether you take Parliament's version of what they pretend happened in the committee, or whether you look at the facts of what actually happened in the committee, either way, it's unlawful. So that brings me, I've just got three quick points. The first is there's a procedural or technical argument raised by Parliament to say we should have challenged the decisions of the committees and not just the decisions of the National Assembly and the National Council of Provinces. And our answer to that is threefold. The first is that it's irrelevant. Our attack is on the National Assembly and the National Council of Provinces. And we say those decisions are unlawful because one of the jurisdictional facts for them to take that decision was a report from the committee that was compliant with Section 8.4. So imagine that Parliament took a decision without any report from the committee. That decision would be unlawful, and we would just challenge that decision. Imagine they had a committee report before them that said expressly, we have not yet taken a decision on the fiscal framework. And Parliament adopts the fiscal framework anyway. That would be unlawful because it would have been taken without a report compliant with Section 8.4.
But did they not have before them a report in terms of Section 8.4? We now know that there had been this problematic process, but Parliament had before then a report which on the face of it complied with Section 8.4.
So that's why I say the first level of our case is that even if you accept that this report was a reflection of the process out of the committee, it's still not a Section 8.4 report because it's because of the recommendation. And the recommendation anticipates the possibility of changing the fiscal framework. So even if one ignores what happened in the committee and just looks at the final report, we come home. But we say there's an additional problem, that the final report before the Houses does not reflect what the committee in fact did. But I can win the case just on the first argument.
I just need your answer on the point you mentioned that they're saying that you should have attacked the report itself.
Yeah.
You're not asking for the setting aside of the report. They say, well, Oldecrowl says that it's a decision on its own which must be attacked on its own until such that you do so, then it stands.
Yes. So we submit that's wrong as a matter of law, and we set out the case law in paragraphs 127 to 128 of our case, which deals with multi-stage decision making. So where often it happens in a tender context or a regulatory making context, where one body makes a recommendation or proposal to another, and the other body has to accept or reject the proposal or take the final decision. And the courts are very clear that in that context, you only challenge the final decision. You don't have to challenge the previous ones because those have no legal effect. They're just recommending to the final decision maker. And that's the case here. The report of the committee has no consequence other than to trigger the power of the Houses to have a vote. That's the only consequence it has. Because it's the adoption by the Houses of the fiscal framework that then triggers Section 8.9 and Section 9.1. So 8.9 is the one that says what the House has adopted. You cannot propose amendments that are different. And Section 9.1 says once the resolution of the National Assembly triggers the obligation to then consider order. And so the committee has no legal consequence under the Moneyballs Act. The committee report. If we come to court challenging the committee report before the House had made a decision, we would have been told you're premature. Why are you here? Wait for the Houses to take a decision. And correctly so.
Okay, can you wrap up now?
Yes, so two very brief points. Just the difference between our approach and the EFF's approach on this issue. We ask for final relief. We want the decisions of Parliament set aside. The consequence will be that the budget, or at least the consideration of the fiscal framework, for this court to act in Part B. That's why we say final relief is preferable, because it deals with the problem, Parliament knows what to do, start again.
It looks like the Commissioner, although he's not part of Part A, has a similar view on this.
Yes.
With regard to the relief sought in Part A.
Yes.
That it should be final relief and not interim relief.
With regard to the fiscal framework.
Yeah, the fiscal framework.
Yes. Yes. And when we submit that is the more appropriate course. It seems more drastic, but in this context, it's actually more respectful of Parliament because it lets them get on with it rather than holding them hostage until this court acts. But it's open to this court to grant either. Finally, on costs, Milady, we submit BioWatch clearly applies to this case. So if we are successful against Parliament, we seek our costs. If we are successful against the Minister, we seek our costs, but I'm aware that in interim applications, sometimes costs stand over the Part B. So we would have no objection costs as against the Minister, because that's interim relief, are costs in Part B. Both the Minister and Parliament ask for costs against us if we're unsuccessful, because they say the Democratic Alliance is a political party here for political reasons, and therefore BioWatch doesn't apply. That's wrong. The case that says it's wrong is Democratic Alliance versus President of South Africa. The citation is 2014 4 SA 402 WCC. It's a decision of this court, paragraph 108, where Justice Rogers, exactly the same argument made. This was a challenge to e-tolling legislation. Exactly the same argument that the DA is politically motivated and therefore can't be protected by BioWatch. And what the court says is, one must have regard to the character of the litigation itself. The present case raises genuine and substantive constitutional issues regarding the approach to tagging. The application is by no means frivolous or vexatious or manifestly inappropriate, and therefore BioWatch applies. BioWatch says expressly in, I think it's paragraph 16, that the motive is irrelevant. What matters is the character of the litigation. And so the fact that my client is a political party is irrelevant to applying BioWatch. Those are submissions.
Thank you, Mr. Bishop. Anything from you?
No, I've got no.
Okay, Mr. Ngaitobi.
Thank you, my lady. Can I start by acknowledging the fact that it's my first appearance for your leadership in your position.
Indeed.
Thank you, and just a word of congratulations.
Thank you.
I want to make 3 submissions in support of the relief sought by the EFF. We don't have the same problem that the VA has, because we have challenged both the decisions of the Standing Committee and the resolutions of the National Assembly. So the difficulty that Parliament puts up, not that it is valid, but it doesn't apply to us. So the submissions we will make in support of the interim relief to suspend the operation of the committee decisions as well as the adoption by the National Assembly are the following. The first one is a narrow one relating to the VAT rate increase. We will submit that in addition to what Mr. Bishop has said, the VAT rate increase is substantively unconstitutional. I will deal with the implications of Section 9 of the Constitution. The second part of that argument is, I will submit that the process through which the VAT increase was adopted is itself irrational and unconstitutional. In fact, it has elements of deception, because what they did, the minister and those who sponsored the increase created the impression that it was subject to change. When you now read their affidavits, they say that they've always known that it was never subject to change from the 12th of March. So if you are a public representative and you go to Parliament and you tell your colleagues, don't worry, vote with me, this may change, you are deceiving them. And that is an improper use of public power. The third argument would be then to challenge the fiscal framework under Section 8.4 of the Money Bills Act. We have prepared a chronology, which I will refer to when I deal with the third part of the argument. Maybe I should end this up. Hopefully only
Can I just ask you if my constitution that lies there? And my pencil case. It's not there.
So let me then deal with the first argument why we submit that the VAT rate increase is substantially unconstitutional. The first is just to set the constitutional scheme for budgeting decisions, which we have attempted to set out in our heads of argument. From page 1311, paragraph 25 of the head of argument. That's where it starts. The first point we make is that the budgeting power is constrained by the Constitution. All budgeting decisions are constrained by the Constitution. And the constitutional constraint is not only the principle of legality. Another constraint is the Bill of Rights itself. And we say the fact that the Bill of Rights has a constraining effect on budgeting decisions has two implications for us. The first is that when budgeting, there is a positive duty to achieve equality. And that is spelled out at paragraph 25.1 from the Battlestar decision. The second implication is that there is a negative duty not to take regressive measures. Sometimes they're called retrogressive, but the report calls them regressive. But those obligations apply when you are taking decisions such as budgeting. We say that there are a number of judgments that have had budgetary consequences that have been taken by our courts. And the courts have never shied away from making a ruling where the Bill of Rights is implicated simply because the word budget is mentioned. We referred to those cases from paragraph 26.1, Rail Commuters Action Group versus Transnet, 26.2, the Blue Moonlight decision. In fact, Blue Moonlight was even more inclusive because the state argued in that case that it had not budgeted for something. It was not even budgeting, but doing it inappropriately. And the Constitutional Court said it is not good enough for the state to state that it has not budgeted for something, if it should have indeed planned and budgeted for it in the fulfillment of its obligations. And so we say here in this case where the committee itself, because I will go through the report of the committee and I'll isolate the item, took the view that the VAT increase was a regressive measure. It also took the view that the VAT increase would exacerbate inequality and adversely impact the poor. And both Parliament and the Minister simply do not engage with those arguments. In fact, Parliament says it's an irrelevant fact. But it's pleaded expressly in the founding affidavit of the EFF as a material
Can I just ask Mr. Ngaitobi, doesn't this take us to the policy-making arena and yes, the decisions that have to be made by other arms of the state and not the court?
Well, we submit that even if it does, even if you are crafting policy, which is the core function of the executive, it must still comply with the Bill of Rights. And you still have the obligations that are both negative and positive. And so it's not outside of judicial scrutiny. So we say that what the minister also simply does not engage with the arguments. What he does is to traverse trite territory about polycentricity, arguments that have been long rejected because it has long been accepted that the mere fact that a decision is polycentric does not mean that it is immune from judicial review. So we say that our courts have not viewed budgeting as a constitutional holy cow. And we set out all of the judgments that have budgetary implications that have been made from footnotes 20, 21, 22, and 23. So then, what are the facts in this case? What do the facts show? Firstly, the EFF alleged at page 07/24 from paragraph 110 of the founding affidavit expressly that the rights that will be impacted are the rights to substantive equality, particularly of the poor, that stand to be hit the hardest by the unlawful VAT hike. Section 9. Section 10, paragraph 1102. Section 25, paragraph 1103. Section 27, paragraph 11010 and 1105. Section 29. But for my purposes, it's enough to stick to one right, which is the equality right. What the committee itself found, you will see at page 02/128, at paragraph 6.23.3. And this is the conclusion of the committee. I think Mr. Bishop said something about this being a recording of the submissions. No, it's actually a conclusion of the committee. That's how they assessed the evidence in front of them. They said, and you see this at 628, where they say the committee notes that the proposal to increase VAT by 0.5 percentage points in 2025 and 2026, which will take the VAT rate to 16%. The committee further notes the following, so that's their finding. 6.283, that increasing VAT would have a disproportionate effect, adverse effect on the lower and middle income households, exacerbate inequality and the cost of living due to its regressive nature. And later on at 6.286, they say the following, that most stakeholders, however, have strongly opposed the VAT increase, particularly in the context of the ongoing cost of living crisis. That's actually a gross understatement. What had happened is that there were 48 submissions. Only 2 supported the VAT increase. It was PEP and PricewaterhouseCoopers. Every other submission rejected it. So you have a scenario in which the public participation process and the VAT increase is opposed by more than 98%. In fact, it then becomes a farce. The whole participation process becomes totally farcical. So when they say most stakeholders, what should have been here is that about 98% said no. 6.287, they say the following. The committee therefore acknowledges that while the VAT increase contributes significantly to the revenue framework, it raises serious equity concerns and must be carefully monitored for its impact on low-income households. There is a need for ongoing assessment of mitigation measures and transparency regarding the revenue raised and how it supports inclusive expenditure priorities. I will say that there was no such inclusion. They noted the problem, that there are equity concerns, that there should be mitigation measures, but there were no such mitigation measures.
Doesn't this issue not go to the question of ambiguity or the fact that the conclusion reached or the conclusion reflected on the report is not supported by the narration of the committee and what the committee actually debates and finds in its report?
No, look, my lady, if I may say, this is an excellent point. It addresses I had seen it as an equality point, but it's also a rationality point. And then the solution, if one recalls, that was proposed by the minister was to zero rate certain items. But that is expressly rejected by the committee at 6.30, where the committee says, the committee notes the National Treasury's position on zero rating is a blunt instrument, as poor households still pay VAT on non-zero rated products and services. the committee recommends that the National Treasury should consider the recommendations made by the stakeholders on the list of zero-rated items, which include an establishment of an independent expert panel to evaluate. So they did not find that the zero rating is sufficient protection for the inequality problems that the increase would exacerbate. And then at 6.31, as the committee notes the decision to not adjust PIT brackets for inflation, generating 19.5 billion in additional revenue. And then look at what happens next. The committee is concerned about the impact on lower and middle income households and recommends that National Treasury assess the equity implications of the fiscal grant and explore alternative progressive tax measures. And at 6.33 on the same page, the committee recommends that National Treasury and SARS should reconsider these proposals and engage further with the stakeholders to assess the viability of selected alternatives, especially where proposals are supported by credible empirical evidence. So I've taken 6 parts of the report where the committee itself acknowledges expressly that the 0.5% will exacerbate inequality. And this is in a country which already on the Gini coefficient is the most unequal in the world. Now, none of these were actually considered, these concerns, when the decision was made. The mitigation measures that were mentioned were simply not brought into operation. So it's therefore clear on the facts that the 0.5% percentage increase is a regressive measure. It exacerbates inequality. It is therefore in breach of Section 9 of the Constitution. You would therefore expect to find a substantive justification in the answering papers. The problem is that the answering affidavit of Parliament avoids the topic altogether. In fact, it says this is not the issue. It's not clear how they could have come to that conclusion in the light of the EFF intervention that squarely raises the problem. And then you think, well, maybe the minister will give a substantive justification based on the equality concerns. But you also find that the minister does not, in fact, justify the 0.5% other than by saying we need additional revenue to cover a number of other government spending requirements.
Does it not say to ameliorate that we're going to increase the number of goods that are zero rated?
Yes, but that's already been rejected by the committee itself, because it said the zero rating is a blunt instrument because the poor still have to pay for the other goods that are not zero rated. In any event, there is no zero rating right now because it is yet to happen through this independent panel that is yet to zero rating. So at the time the decision is made, there is no evidence of what is the impact of zero rating on the poor.
So by the 1st of May, there will be no zero rating to speak of.
There will be no change in zero rating. But the poor must pay the percentage increase.
Well, in fact, there's no panel yet.
There's no panel at all. So that zero rating, as Parliament said, is a blunt instrument. It doesn't take us anywhere. So we have a scenario in which there is a clear violation of constitutional rights. The 2 organs of state that are responsible for budgeting have forgotten their constitutional obligations to the poor. And we don't have to succeed on a final basis. This is a case that depends on the prima facie right. So we say that is sufficient. And here it is not as if there are no alternatives. And again, they don't have to take the EFF alternative. The EFF says you must tax the rich. But you can ignore that and say that's political rhetoric. But what you cannot ignore is the Commissioner for SARS, who himself says there are alternatives. And those you will find at 02/121 under paragraph 5.2. And the last paragraph there, where SARS is making a presentation, and they say the presentation estimated South Africa's tax gap to be between
Sorry, where are you reading from?
I am at 02/121.
Yes, I'm there, but
Yes, at the last paragraph, under paragraph 5.2.
5.2.
Yes.
Okay, let me just get there.
Yes.
Yes, you may proceed.
So this is what SARS says as clear alternatives. The presentation estimated South Africa's tax debt to be between 700 and 800 billion annually, with only 58% of the theoretical tax liability being collected. So that's 42% uncollected tax and on time. SARS identified key under-resourced areas, including illicit trade, syndicated tax crimes, aggressive tax planning by large businesses, international tax compliance, high net worth individuals, cost of entry, and debt recovery. So that's where they say the money will come from. SARS outlined immediate and medium-term plans to enhance compliance and revenue recovery. These include expanding the debt default recovery program, which is in a pilot phase, resolved over 600,000 cases and collected 25.2 billion in cash over 15 months at a cost of 300 million. SARS plans to increase full-time equivalents from 858 to 2,500, with the goal of collecting 20 to 50 billion annually. Additional strategic investments of 2 billion per year are required to support this effort. And then that goes on to the last paragraph in that page. So the point is that Parliament itself and the Minister himself were told by the Commissioner of SARS that they are alternative to the VAT increase. They were not told by my clients or the DA or anyone. They were told by their own commissioner.
I'm just going back to the policy choice question and the courts of how far can the court interfere in that arena, where SARS says and the minister says, well, these are the policy choices that we've made. We've looked at alternatives, and we find that it will leave the poor worse off than this other one. Can the court say that?
Yes, if the Bill of Rights is implicated. But the problem is that the Bill of Rights is actually a trump. So you have to make those. The law is not that the government can simply assert that we've made this policy choice. The law requires the government to account by reference to the standard in the Constitution for why they have made policy choices and why they have rejected certain alternatives which were made and have made available to them. So there is no constitutional blank check simply because you use the phrase budgeting. And so that's just a narrow case. It's circumstances where, one, it's clear that there will be an exacerbation of inequality, and two, it's clear that Parliament itself says there will be inequality, and it's clear that there are available alternatives. It's arbitrary then in those circumstances to suck your thumb and say, I'm sorry, I want to increase. So what we are asking the court to do is to be more exacting in the evaluation of the conduct by the minister. So we submit, therefore, that there is a strong substantive argument in favor of suspending the decision pending a review in Part B. And we say when we actually evaluate the answering affidavit, there are no direct answers. But when you look at the answering affidavit of the minister, it starts at paragraph 68 in the EFF answer, just never answers anything that comes before paragraph 68. Then I must move on to the second problem that we have, specifically just on VAT. The second problem is that what they seem to have done, the minister and those who promoted this vote in Parliament, is that they have simply said, look, since the Action SA fell for it. But it doesn't matter, Action SA were acting as members of Parliament, not as a separate political party. Also say, look, don't worry about this. We can put in a condition that we will change this in due course. So vote for it. Now, there is a fundamental problem with adopting that approach. It may be politically convenient, but it's deceptive. And public power should not be used deceptively. Public power, the first and the primary duty is that you must be honest.
Now, the minister's decision has not been directly attacked by the EFF.
No, we say that we don't have to, because our challenge is, because you remember that the deception did not come in the introduction on the 12th of March. It came on the 1st of April. So we say you've got to look at his conduct in totality. his conduct in totality reveals deception.
Yes, no, I understand that, but what I'm saying, the relief sought, there's no, if I recall, there's no order sought against the minister's decision to say you impugn this decision, this conduct, and therefore the decision must be set aside or must be reviewed or we must do something about it. So there is no direct challenge against the minister. That's what the challenge is against the reports of Parliament.
Your leadership is correct. What we submit there is this, that the minister's decision under Section 7.4 is part and parcel of the budget. Unlike the DA, we don't accept that if the fiscal framework is set aside, there is a self-standing decision of the minister that survives the setting aside of the fiscal framework. Our reading of Section 7.4 is that the two are inextricably connected, especially when you look at the text of the section, which says if an increase is contemplated as part and parcel of the budget under Section 27 of the PFMA, then the following must take place. We see that as meaning that because the increase is part and parcel of that budgeting in the fiscal framework, once that budgeting in the fiscal framework falls, so does the minister's decision.
So once the resolutions from Parliament are set aside, yes, then you're saying Section 7.4 cannot come into operation, or rather the announcement cannot become effective on the 1st of May?
Not independently. Because this is what the minister again has said, it really becomes a problem when politicians act like this. Throughout, the minister did not on the 1st of February say that I'm trying to increase VAT. He said on the 12th of March, I'm trying to introduce a budget that includes a VAT increase. That's what he said. Throughout, he always accepted that the two go hand in hand. The first time there was a theory of separation is when the answering affidavit was filed. So even his own conduct showed that he understood the two to go together. So that's why it's not appropriate right now to try and separate the two. The two decisions are one and the same.
So the VAT increase is tethered to the annual budget.
Precisely.
And tethered to the annual budget is a resolution approving the fiscal framework.
Precisely, yes. And throughout the debate, the main issue that these parliamentarians debated was the VAT increase. When they were trying to adopt the budget and trying to pass the fiscal framework, they were debating the VAT increase.
But where's the deception?
No, that is not the deception.
Oh.
The deception is the idea that this is subject to change. When they knew that they had no intention of changing, that was deceptive.
Is that not politics?
Yes, there is no problem with the politics per se, but what we are concerned with here is the conduct of the members of Parliament in Parliament and the message they are sending to us as the voters. Now,
but Mr. Nkatobe, isn't it perhaps just a misunderstanding of the whole legal framework of the fiscal framework? How it impacts and how it fits into one another. Wasn't there perhaps a misunderstanding rather than a deception?
There could be there could be a misunderstanding, I accept that. But where the minister today, one looks at his answer and says that I never thought this was going to change from the day I announced it on the 12th of March.
So he knew beforehand?
He knew beforehand. So it can only be deception when in Parliament the impression was created that these recommendations can be put and these recommendations can be altered. In fact, my Lord, I'm glad you raised that question because it's not me saying this. It's actually Mr. Athol Trolliper. If you go to page 07/18.
Just give me a second. Yes, I'm there.
Yes. So 07/18, paragraph 47 says Athol Trolliper, who is an MP and Action SA's national leader, is on record making this exact point in a media briefing he hosted on 2 April 2025, following the National Assembly and NCOP's adoption of the impeachment report. In that briefing, he made the following statement. 47.1, as per its negotiations with the ANC, Action SA's support for the fiscal framework is conditional on the finance minister scrapping the VAT increase recorded in the annual budget and fiscal framework. 2. Having expressed his irritation with his perception that the ANC is reneging from its appointment and misrepresenting the facts leading to the adoption of the impugned report, Trolip asserted that the ANC must implement Action SA's recommendations, which were the preconditions as stated. 3. Pulling out his phone and reading his negotiation exchanges with the finance minister, he stated that the latter said to him, "I imagine you will be able to come up with proposals to replace the revenue proposals," to which Action SA made its conditional support proposals. It was at this point that the poison tree blossomed and gave rise to the impugned report fruit. It is that sequence of events that gave rise to this the amendment proposal, as agreed with the finance minister and the ANC. Then it goes further. 4. Trolip went on record that following that precondition and concession, Action SA then approached and convinced Bosa and Rise and Zanzi to vote in favor of the impugned report adoption. He repeated the condition in another interview, to which I will refer to in a moment. So, it is him who says the minister has misrepresented the truth. So I say that the minister is guilty of deception. So once you have a budgeting process that is so colored by deception, it is fundamentally in breach of the duties imposed on members of parliament, especially our executive, national executive committee. So you cannot endorse a budgeting process where the deception is so clear. And in fact, you know, my lady and my lord, I've been reading from paragraph 47. If you actually go to the minister's answering affidavit, so fine. The answering affidavit starts at 035. There's something that will shock you, because the answer to the EFF is at 0351.
Zero?
0351.
Yes,
that's where the answer to the EFF starts, the seriatim. And you see where it starts at paragraph 85. And at paragraph 47, which is where the accusations of misrepresentations are made, is just not answered.
Sorry, you on
0351, and I'm comparing that with 0719.
Okay, yes.
So if you go to 0351, where they start the seriatim response to the EFF at paragraph 101, they started at paragraph 85. So compare that with paragraph 47, where the accusation is made by Trolip that the minister is guilty of misrepresentation. That is a very, very serious accusation. You would have expected that it would be met frontally. It's just not an answer.
So what must we make of that now?
Well, it still comes back to whether or not a report that is undermined by deception and misrepresentation can pass the rationality standard. Because remember, the EFF challenges this report on substantive unconstitutionality and irrationality. One of the grounds for irrationality has been highlighted by the leadership presiding, which is there's a mismatch between the content and the outcome. But another one is that this is a report that is a product of deception. It's not honest what happened here.
So at the time the minister engaged Action SA, he knew that the VAT rate which he announced on the 12th of March cannot be changed.
That's what he says now in the answer affidavit. He says, from the onset, I made my decision on the 12th, and that was it. So then that calls into question then what on earth was it doing with Trolip lying to him? So you will see this right at the beginning of the minister's answer affidavit. I'll find it now. Yes. starts at 03.12, paragraph 15, where it says, I exercised this statutory power, talking about section 7.4, on 12 March 2025. 10 minutes, please. There is a specific paragraph that says that it's where they deal with the separation, where they say it's clear that these two are separable, and once announced, it cannot be changed. I will find it. If I don't find it before I finish my argument, I'll tell the court at a later stage. Yes. It's 0324, where he's talking about the implementation of the VAT decision. So paragraph 48, and then paragraph 50, where he said, that said, the decision as to whether to give permanent effect to the VAT rate adjustment now lies with Parliament. In due course, Parliament will consider.
Sorry, let me just get there.
0324. So the first one is the very top of 0324, paragraph 47.
Let me just get there.
In fact, 0323, paragraph 46, that's where it starts. Yes, I've now found it.
Yes.
Since its announcement, the decision has been widely communicated across the country, and businesses and consumers alike have relied on it in planning for the financial year ahead. Paragraph 47, the VAT rate is therefore set to increase to 15.5% on 1 May 2025. And paragraph 50, at the same page, that said, the decision as to whether to give permanent effect to the VAT rate adjustment now lies with Parliament. In due course, Parliament will consider and debate proposed legislation, and to the extent it sees fit, pass or amend it in accordance with the procedures set out in the Manifest Act. So it comes back to this point I'm asking rhetorically. What was he doing misrepresenting to Tony Trolley, which he has not answered in our founding of the day, when he knew on the 12th of March that on the 1st of May, this increase comes into operation? What were they trying to achieve when they said there is 30 days from which you can come back and re-debate the issue? So I'm saying that deception is anti-constitutional.
But is it not so, Mr. Nkatobi, that it ultimately was in the hands of Parliament?
Well, it is still, technically speaking, now in the hands of Parliament, right? What I am suggesting is that even in Parliament, if a vote is procured through deception, it is still unlawful. You could say that it is a matter of politics, and you've already said so, Justice Savage. But I'm not sure what that means.
That's a question. I'm not a politician.
Yes, I'm not sure, Justice Savage, what that means, because there are several candidates about what that statement might mean. The one is that South Africans must accept that politicians will lie in the course of doing business. I don't have a problem with that. I have a problem with it when they're discharging constitutional functions. But if they're sitting in Lutuli House and lying to each other, there's no problem. But what we are dealing with here is a matter of immense national importance.
Do we not know that what was occurring was the ANC was needing support for its budget? So it was looking for supporters. It was looking for support from other political parties.
Yes.
So that was part of the process, was trying to secure them.
It is absolutely clear. That's what they were trying to do. The problem
but there's nothing wrong with that, but they shouldn't deceive the public.
Precisely, because the contamination with deception is in the report itself. Because it's the report that says we're coming back in 30 days. So once the report is contaminated by that deception, then it is unlawful. It cannot be given legitimacy by the court.
I just want to understand, there's two players here. We're talking about deception by Parliament or the committee, and the deception by the minister.
Yes.
So the one you're dealing with is the deception by the committee.
Yes.
And is that, did the committee actually understand? Didn't they think that, well, ministers must still come back to us? Is it a matter of deception, or is it a matter of maybe misunderstanding the legal framework or the 7-4 powers that the minister has?
There are two candidates to this. Maybe the two of them are together. Certainly on the minister's side, who now claims that I've made my decision, it comes into effect on the 1st of May, a case of deception can be established. But when it comes to what were the parliamentarians doing when they included in the report that this matter will come back, were they trying to deceive the public or were they genuinely confused? If they were genuinely confused, it's still irrational.
No, I get your point. Thanks.
Now, so we will submit, therefore, that on both of those two grounds, there is a substantive unconstitutionality problem and a deception stroke grave confusion. Both of those contaminate the VAT rate increase so significantly that it cannot be given a stamp of approval by this court. That takes me then to the last of the three. That takes me to the last of the three, which is what actually happened in the committee. So the starting point here is section 8.4 of the Management Amendment Procedure Act. So the section states the following. So section 8.1 starts by saying that the National Assembly and the National Council of Provinces must refer the fiscal framework and revenue proposals to their respective Committee on Finance. So there is a clear obligation that it must go to the Committee on Finance. Section 8.2, the committees must conduct joint public hearings on the fiscal framework and revenue proposals. Section 8.3, the committees must, within 16 days after the tabling of the national budget, submit a report to the National Assembly and the National Council of Provinces, as the case requires, on the fiscal framework and revenue proposals. And then section 8.4, the report must include a clear statement accepting or amending the fiscal framework and revenue proposals. So there seems to be three distinct duties. The first is the National Assembly duty to refer the fiscal framework and the budget to their committee. The second duty is, once it is in the committee, there is a duty to conduct joint public hearings, both on the fiscal framework and the revenue proposals. And it must be tabled to the NCOP, but when it is tabled, that report must include a clear statement accepting or amending the fiscal framework and revenue proposals. The EFF's case on this score is twofold. The one is to criticize the process of deliberation that took place at the committee itself. That process of deliberation was farcical. Now, if your ladyship, and my lord, go through the document I handed up, you will see a comparison. I think it's the 8th page. You will see a comparison drawn from the figures of what we say happened at the committee. And there are 10 items that have been isolated there. And what the speaker says and what the minister says. And so we've classified this in the heads of argument as absence of deliberation, and we've cited various constitutional judgments that show that the heart of Parliament is a deliberative assembly. So there has to be a meaningful engagement and a meaningful participation in the substance of what is presented before them. So the first one is that the criticism is that there was a request to the speaker by the EFF.
Paragraph? Which paragraph?
Well, it's the first paragraph, paragraph 12. These are not numbered, but they are in table format.
Okay.
This is the letter that was sent to try and stop the vote.
To try and stop it, yes. Which is admitted, but the minister says nothing about those. But the point here that is made is simply this: these are not the irregularities were brought to the attention of Parliament. It is not as if Parliament was unaware of the irregularities of the committee that were brought to its attention. So it approached this task with its eyes open about the problems. So it therefore accepts it. I know that the Speaker of Parliament responded to the DA and said that her advice is that there were no irregularities. That's all fine. But the point here is that if there were irregularities, these were brought to the attention of the Speaker prior to the vote. And so when they voted, their vote was to endorse those irregularities, which is not allowed by the Constitution. Then the second allegation that is made is this, and I think it was debated when Mr. Bishop was writing, which is, however, this conclusion and the insertion in the impugned report, that's the insertion of the word accept, was done post the sitting of the Finance Committee and was not in fact deliberated upon and concluded by the Finance Committee, despite Sinawo Tambo, who is from the EFF, having proposed at the beginning of and halfway through the sitting that the Finance Committee starts off by taking a position on whether it accepts or wishes to amend the fiscal framework, which would in turn inform the report it was sent, not the other way around. Now look at what the answering affidavit says of Parliament in the next column. It is correct that the insertion was made post the sitting of the committee. I refer to what I've stated and maintain that it reflects an accurate account and statement of what occurred at the meeting. The remaining allegations are denied. Now that allegation is very important because she never identifies where the item that is being voted on, accept or amend, is ever presented to the committee during the deliberation to vote on. Never identifies that.
It's common cause, it was not there.
It was not there. But what is concerning is the bold denial by the Speaker, who is herself a repository of public power, where she admits that the insertion came afterwards. And then there is a third, and again, this is not a technical fight. It's a fundamental element of Section 8.4 based on the rule of law. They have been given a power, and the Parliament has decided this is how the power is to be exercised. But they themselves, as lawmakers, are just deciding to ignore it. And then,
Mr. Mkatobi, in that regard, it's also common cause that on the same day of the report, the 1st of April, both the EFF and the DA, their representatives from the committee email the secretary of the committee and say that's not what was agreed in the committee.
indeed.
And this report does not accurately reflect the situation.
Yes, indeed.
And the following day, in spite of that, and in spite of then letters to speak about by the DA and the EFF, to say don't go ahead with the vote.
Yes.
It's rushed through and the vote's held.
Yes, they ran through. They thought, we've got this gap now because Action SA is with us. Let's put it through.
Arguably, there would be a basis in which to say that an issue could be discussed by a committee, and the report could be a correct reflection of that report after the fact could then be sent to Parliament. In certain circumstances, fact dependent, that might be acceptable. But in this case, the facts show completely the opposite.
Yes, the facts show that the report was a distortion of what had happened. And that distortion was brought to the attention of the Speaker. The Speaker nevertheless ignored it.
What is to be made of the word approved in the minute?
Whatever that word means, even if it means accept, it is still undermined by the condition, which is also included in the report. Because the section says clear statement, and once you put the condition, it takes away the clarity. So it's the main argument, by the way, by the Speaker, is to say sometimes they use approve, sometimes they use adopt, but they always shy away from accept, which is the language in Section 8.4, because they know that accept is not conditional, even in contract. If you say I accept, but that's not an acceptance. So the third irregularity is then identified in the following section, which again is objections being raised, and when you look at the answering affidavit, that's not being addressed directly. And then the fourth one is a fifth one, okay, a sixth one, again no answers. A seventh irregularity, an eighth irregularity, and what you say is the content hereof is denied, the content hereof is denied. The ninth irregularity, and the 10th irregularity. So we've taken the time to go through this quite carefully, and we've come up with 10 irregularities which simply cannot be answered. So I'm afraid what you have, what the court has, is that it has a report that is so fundamentally undermined by the irregular way in which Parliament conducted itself, which is in conflict with Section 8.4, and therefore cannot be given effect. What that really leaves is, well, can you do the separation? We've showed in our heads of argument that you can't come and rely on a different section after the event. If the minister's case was always, I'm increasing VAT, I don't care about the budget and I don't care about the fiscal framework. That was never his case. That case came in the answering application. So therefore, he was always trying to increase VAT as part and parcel of the budget and the fiscal framework. So he's bound by that election. Then, well, what is the court supposed to do? Well, we submit that it's inevitable that relief must be given to the EFF and the DA. The question is whether interim relief on the fiscal framework or final relief. We've asked for interim relief. Mr. Bishop, as I understand him, says that interim relief might not be appropriate because it would sterilize parliamentary processes until Part B is ready. It's unclear to us why it would, because if the current process is interdicted, it's clear that they may not proceed with it. But that doesn't mean they may not start a new lawful process.
Can I just ask paragraphs 3 and 4 of the relief, which suspend the report of the standing committee and then the reports of Parliament after that? Has the boat not sailed in respect of that report? What would the suspension of the report do? Because that has already been, that's gone through the process and voted on. And so what would the suspension of the report of the standing committee do at this stage?
Well, my lady, we do ask in paragraph 4 for the suspension of the National Assembly resolutions. What we were worried about is that the court might say that there was nothing wrong with the National Assembly resolutions, and therefore we had to attack both of them. But again, if you only gave us paragraph 4, theoretically, you still have the problem that you've got the poisoned report of the standing committee, which still remains and has not been suspended.
I think my question goes to, is it not the setting aside that should be granted rather than a suspension? Because a suspension,
yes.
what does it really do?
Yes, it may not be just an equity. Let me just say this. The relief that should be given is just an equitable under Section 172, and that's what Kodan says. And also says that you are not bound by my formulation of the remedy. What you must give is what is just an equity.
So if it was final relief, you would be,
yes,
you would be covered.
That would be given. I submit that I do meet the threshold for final relief, but we had asked for interim relief. But the fact is that the facts are so clear, and the law is so clear that the court will be entitled to give final relief in its discretion. If the court gives final relief to the DA, then my arguments are only supplementary to the DA. I don't need separate final relief.
Okay. If, for instance, we give final relief to the DA, and then paragraph 5, which is the interdict, would still stand. Is that right? Is that what you're saying?
Yes.
So in respect of 3 and 4,
Yes.
we can actually give the final relief in respect of that, but paragraph 5 still stands because that's the interdict pending Part B.
Yes. Indeed, because there is Part B even on the DS formulation of the case. But I still need Part B anyway because I need to finally set aside the VAT increase.
Okay. So Part B in this instance would only be in relation to the VAT increase and not the report, because the reports would have been catered for in the final relief.
If you give the DA final relief, then I don't need any final relief. My arguments will simply support what the DA has said.
Okay.
But it's in that event that you think final relief is inappropriate that I say my paragraph 3 and 4 are appropriate.
Okay.
I have nothing else to add.
Costs,
Well, entitled, there are 4 of us. We should be entitled to cost of 2 counsel. The case is sufficiently complex. We are immunized from cost by Biowatch.
Yes, we can start a quarter to 2.
Thank you, Mr. Ngugaitobi. Can we perhaps break early, now at 1:45, come back at 1:45? We'll make arrangements that you come in, you're allowed to come in at 1:45. All right, quarter gents until 1:45.